Hello and welcome to the third module of our training tool on strategic litigation designed for professionals working with destitute EU migrants. This is a series of 6 training modules on strategic litigation in EU free movement cases, which is designed for professionals working to promote and protect the rights of destitute mobile EU citizens. This third module addresses judicial remedies and focuses on how to get the EU Court of Justice involved in enforcing EU residents' rights. The European Court of Justice is the institution tasked with the final say on the interpretation of EU law. It does this by issuing binding legal opinions in the form of a judgment in the so-called preliminary ruling procedure. We will now see how the Court of Justice can be involved in strategic litigation. When EU citizens and their family members move to an EU country other than their own, they may become the target of a measure which restricts their free movement rights by the national administrative authorities of the country where they've moved to. Such a measure may be in breach of EU law as a result of a restrictive interpretation of key concepts of EU law, which we discussed in Module 2. Those who are affected might turn to civil society organisations for help. They may also turn to a lawyer or be referred to one. In order to take action to enforce EU residents' rights, it is necessary to challenge the measure which is the origin of the restriction, for example, a decision to refuse to issue a residence card. This can only be done by appealing the measure at national level. It is not possible in these kinds of cases to go straight to the European Court of Justice. Instead, an appeal needs to be brought before the national courts to try to overturn the measure, in our example, by appealing against a decision to refuse to issue a residence card. As part of the judicial proceedings, it is possible to request the national court make what is called a referral for a preliminary ruling to the European Court of Justice. The point of this is to challenge the restrictive interpretation of key concepts of EU law and ask the European Court of Justice for a binding legal opinion on how this key concept should be correctly interpreted. The Court of Justice will then issue a judgment which the national court must follow. Hopefully, this will be in line with a broad interpretation of key concepts. The national court can then issue an order which overturns the restrictive interpretation of EU law which had been followed by the national administration. The EU court may also find that the underlying national law or practice is contrary to EU law. In that case, the member state concerned will be under a legal obligation to amend their offending law or practice in order to bring them into compliance with EU law. Further details on how individuals can bring a case to the European Court of Justice can be found in this official video from the court. A link to it can be found on the list of useful links included below this video. The recent GMA case gives an example of what can be achieved with strategic litigation. Back in early 2016, the EU Rights Clinic was approached by GMA, a Greek citizen who came to Belgium looking for work. He registered with his local municipality. After he'd been looking for work for 4.5 months, the Belgian Immigration Office refused his application for registration and ordered his removal from Belgium. With the help of Fianza under the PRODEC project, we helped GMA to appeal the decision to refuse recognition of his right to residence in Belgium. The case sought to challenge the administrative practice of the Belgian Immigration Office, which consists in only allowing job seekers 4 to 5 months to find a job in Belgium before refusing to register their residence. Previous EU case law in the Antonissen case suggested that job seekers could be given a minimum of 6 months to find work. In addition, the case also sought to challenge offending provisions of Belgian law, which require job seekers to demonstrate that they have a genuine chance of being engaged from the time they first register in Belgium, as opposed to only having to prove this if they have not been able to find work within 6 months of their arrival in Belgium. The case was challenged before the Belgian Council for Alien Law Litigation, which dismissed the appeal and ruled in favour of the Belgian Immigration Office. We then appealed before the Belgian Council of State, the higher administrative court, and asked for the matter to be referred to the European Court of Justice. The question which was referred to the European Court of Justice contained 3 requests. First, to confirm existing case law about job seekers having to be given a reasonable period of time to look for work. Second, to decide that this reasonable period of time to look for work should in no case be less than 6 months. Third, to confirm that during this period of 6 months, a job seeker does not need to demonstrate having a genuine chance of being engaged. The case was brought before the European Court of Justice in September 2019, and a judgment was handed down in December 2020. The court ruled in favour of GMA, and essentially decided that a job seeker must have a reasonable period of time to look for work, and that a period of 6 months is not insufficient for this purpose. The court also ruled that Belgian law was not compatible with EU law in requiring job seekers to demonstrate that they have a genuine chance of being engaged from the time they first register in Belgium. The case was then sent back to the Belgian Council of State, which overturned the first-level judgment of the Council for Alien Law Litigation and sent the matter back for final determination. In a subsequent decision, the Council quashed the decision of the Belgian Immigration Office. However, this is not the end of the matter, as the offending Belgian legislation remains on the statute books. We have therefore lodged a complaint before the European Commission to request it launch infringement proceedings against Belgium. We will discuss this further in Module 5 on complaints to the European Commission. Although in theory individuals may turn to the national courts to enforce their rights, in practice individuals may face several obstacles. The complexity of court proceedings means that obtaining the assistance of a lawyer is highly advisable. A lawyer may also be necessary to navigate restrictive rules on evidence which might apply to court proceedings. For example, in Belgium, it is not possible to submit new evidence that was not brought to the attention of the Immigration Office before it took its decision to refuse residents' rights. Costs may also act as a deterrent. Not only must an individual pay for court fees, they also need to pay for a legal representative. Legal aid is not always available, and in some countries has been cut completely for immigration cases that do not involve asylum applications. It is also crucial to know about timing issues, as there are often strict filing deadlines. The length of proceedings also needs to be factored in. Court proceedings in these kinds of cases take time. For example, the GMA case took over 6 years to wind its way through the court process and obtain a final decision in favour of the individual concerned. However, organisations can help find solutions to these problems. Organisations can help overcome some of the complexities of court proceedings. They can help by putting their beneficiaries in contact with a specialised lawyer who can take on their case. They can also help beneficiaries collating evidence and obtain documents which can be useful to their case. Organisations can also mitigate costs. They can help their beneficiaries to apply for legal aid. They can also make use of opportunities for crowdsourcing funding. As part of their operating or project-based budgets, they can also make provisions for funding strategic litigation. Organisations can also help their beneficiaries to find legal aid. And if this is not available, they can help their beneficiaries find alternatives, such as pro bono services offered by law firms and specialist organisations. Organisations can also help their beneficiaries to address timing issues. They can help to raise awareness of relevant deadlines when filing an appeal. They can also support their beneficiaries throughout the lengthy court process. We will now engage in a practical exercise. Please consider this situation. You are working as an advisor for Focus Ireland. Günther, the German national living in Cork, who has previously contacted you, calls you again. He received notice of termination of his employment 2 weeks ago. He'd worked in Ireland for only 2 months. He immediately applied for job seekers allowance, but has been refused on the basis that he is not habitually resident in Ireland because he's been resident there for less than 3 months and he's been told he cannot demonstrate that he has a right of residence under EU law. His request for an internal administrative review by the Social Welfare Appeals Office has been rejected. What would be the most appropriate course of action to advise? Is it 1. Günther should be advised to appeal the refusal before the European Court of Justice? 2. Günther should be advised to bring an appeal before the Irish High Court? Or 3. Günther should be advised not to appeal because there is a risk that he might not win the case? The correct answer is 2. Günther should be advised to bring an appeal before the Irish High Court. As we mentioned earlier in this module, in such kinds of cases, individuals cannot appeal a decision refusing recognition of residence rights directly to the European Court of Justice. The fact that Günther might lose his case should not be a determinative factor not to appeal, because on the face of it, the decision of the Irish authorities is not correct, given that he has previously worked in Ireland for 2 months. The appropriate course of action is to appeal the refusal before the Irish High Court. If the case raises a question on the interpretation of EU law, this may form the substance of a request for a preliminary ruling before the European Court of Justice, and the Irish High Court may accordingly be invited to make such a request in the appeal pleadings. A list of further useful links, including videos about the European Court of Justice, should appear below this video. This concludes our third module, which sought to provide an overview of judicial remedies in residence cases and how to get the EU Court of Justice involved in national court proceedings. We hope you found it useful.